Good morning, everyone. Sorry, good afternoon, everyone, and good afternoon, Mr. Rajapakse. How are you?
Good afternoon, Sakib. Good to see you again.
Sorry for the delay, sir. We were just like waiting for some of the participants to join.
Of course,
Uh, Assalamu alaikum, Rahul, sir.
that's
How are you,
fine.
sir? Sir, you are muted. Sir, you're muted.
Uh, Assalamu alaikum wa rahmatullah. Afternoon, everyone. How are you?
I'm good, sir. Thank you. For those who don't know,
Thank you.
Ruhul sir is our governing board member from Bangladesh, and we are very happy to have him here with us for our webinar. So we will just start with the webinar. So just for brief introductions, everyone. Good afternoon. My name is Barrister Sakib Mangrio, and I'm the Assistant Director Law at the SARC Arbitration Council. It is my privilege to welcome all of you to this important webinar titled Navigating Practical Challenges, Strengthening Arbitration Institutions and Enforcing Arbitral Awards in Sri Lanka. I want to take this opportunity to express my gratitude to our highly distinguished speaker and to all of you who have taken the time to join us. Your participation is what makes this webinar a valuable platform for dialogue and development. The focus of today's webinar, Strengthening Arbitration Institutions and Enforcing Arbitral Awards, goes to the heart of Sri Lanka's ability to offer businesses a reliable, efficient forum for resolving disputes. As commercial activity grows and contracts become more complex, practical bottlenecks emerge, uneven case management, limited institutional capacity, and delays or uncertainty at the enforcement stage hinder the process. Even well-crafted awards lose their value if recognition and enforcement are slow, unpredictable, or procedurally fragile. Building robust institutions and a clear, consistent enforcement pathway is therefore essential to credibility, cost control, and investor confidence. Our discussion today will take a look at practical solutions as to how upgrading institutional rules and case flow management, strengthening panels and training, improving court arbitration coordination on interim measures and set-aside applications, and how streamlining recognition and enforcement to align with international standards will improve this process. The aim is not theory for theory's sake, but tools that shorten timelines, reduce costs, and enhance certainty for parties. As we begin, I invite you to bring your experience, questions, and concrete ideas. It is through this exchange that we can chart a realistic path to a faster, more trusted arbitration ecosystem in Sri Lanka. As we begin, I invite you all to openly engage with today's presentation. It is through this exchange that we will identify workable reforms, build professional capability, and chart a clear path towards a sustainable ADR culture in the SARC region. Here's to an engaging and productive session ahead. Now that we have formally started with this webinar, I'd now like to introduce the current presiding Director General of SARC Arbitration Council, Mr. Choining Doji. Mr. Doji is a seasoned legal practitioner and has previously served as a member of the National Council in the Kingdom of Bhutan. Additionally, Mr. Doji has also served in the Royal Civil Service Commission Bhutan as well as in the Anti-Corruption Commission of Bhutan. Mr. Doji is our fifth Director General, and it has been due to his guidance and support that SARCO has been able to continue its important work of promoting the use of ADR in the SARC region. Please allow me to welcome Mr. Doji to give the welcome remarks.
A very good afternoon to all the participants. Once again, I welcome especially to our GB member from Bangladesh and also to the resource speaker, Mr. Rajapaksa. Nice to see you again. And welcome to the webinar. I look forward to continue the partnership in the same spirit. I think Shakib has just said whatever we need to be said, but I would like to add few things, especially the reason why we are conducting this webinar. Actually, as initially planned, our idea was to really keep a hands-on training based on the requirement of the arbitrators in Sri Lanka. It was intended as physical activities, but somehow because of so many issues we are facing right now, including financial issues, so we have to convert this webinar, I mean the physical activities, into a webinar. And there's a reason why we have this webinar today. And this is pursuant to our mandate to promote the growth and functioning of the arbitral institutions in the member states. Every year, as I mentioned earlier, we organize a series of workshop, seminar, or tailor-made training programs in member states. So this webinar is one of the events in this series. And I hope, given the experience, vast experience, knowledge, and expertise which we have in our resource speaker, I hope to get, including all the participants, a lot of information, insight from our resource speaker. Finally, I wish all the participants joining us from different locations very fruitful, engaging, and enriching webinar. I thank you all.
Thank you, sir. Ladies and gentlemen, for our main thematic session today, which will provide an overview of the Sri Lanka's arbitration landscape with a focus on institutional strengthening and enforcement of arbitral awards, we have with us to deliver insights one very renowned speaker, namely Mr. Amrit Rajapakse. Just to give a very brief background about Mr. Rajapakse, Mr. Rajapakse is a dispute resolution counsel, arbitrator, and legal consultant with over 2 decades of experience in litigation and alternative dispute resolution in Sri Lanka. He has acted as tribunal chair, sole arbitrator, and co-arbitrator in over 40 domestic and international arbitrations spanning construction, finance, agency, and commercial disputes. Mr. Rajapakse is a fellow of the Chartered Institute of Arbitrators and a director of its Sri Lanka branch, and is impaneled with leading institutions including the Singapore International Arbitration Center, the WIPO Arbitration and Mediation Center, and the Maldives International Arbitration Center. He has been recognized in the Chambers and Partners Asia Pacific rankings for dispute resolution and has contributed to national area law reform initiatives, including the recent Mediation, Civil and Commercial Disputes Bill. In addition to his practice, Mr. Rajapakse is an active lecturer and speaker committed to advancing best practices in arbitration mediation. We've had the pleasure of working with Mr. Rajapakse last year during our collaboration with the International Media Center, Sri Lanka. And we are once again extremely grateful to have you as a guest today, sir. And now I'd like to invite you to take the floor.
Thank you so much, Saqib, for the very kind introduction. I'll just put my slides up. Are my slides visible to you?
Yes, we can see them.
Thank you. Mr. Chovidik Dorji, the Director General of SARCO, Mr. Saqib Mangrio, Assistant Director Law, SARCO, distinguished colleagues, ladies and gentlemen, friends. It's a great honor to be invited by SARCO to give this webinar today, an overview of the arbitration landscape in Sri Lanka. And I recognize among those of you who are joining today several of my colleagues from Sri Lanka. So I hope that you will also contribute where necessary to make this a more engaging and an interactive discussion. I'm also very pleased to see the interest from our colleagues outside Sri Lanka. So please also feel free to share your own perspectives from your jurisdictions. And I'm sure that a lot of these problems will have common solutions. So it will be useful to hear what your experiences are as well. I plan to take around 45 to 50 minutes on my presentation. It's an overview, and the title that I'll be talking about is Navigating Practical Challenges, Strengthening Arbitration Institutions and Enforcing Arbitration Awards in Sri Lanka. So there are a few topics that I'll be addressing. I'll start off by giving those of you who are not familiar with the Sri Lankan landscape a brief introduction to the ADR landscape that we have currently. Then I'll give a very brief overview again of the legal and institutional framework, specifically dealing with arbitration in this country. And then I will identify some of the challenges and constraints which have been identified in relation to arbitration practice in Sri Lanka. Then I will move on to focus specifically on the role of arbitration institutions. And following that, I will also focus on enforcing arbitral awards in Sri Lanka and the role of the Sri Lankan courts. Finally, I will end with some thoughts on recommendations and way forward. So to start with, just a snapshot of where Sri Lanka stands in relation to our regional colleagues in relation to contract enforcement. The World Banking business, which was discontinued after 2020, it has been replaced with the Be Ready, business ready ranking. However, Sri Lanka has not yet been ranked. So the last available ranking is from the Doing Business Report of 2020. So here we can see among our regional partners, in relation to contract enforcement, Sri Lanka is ranked at 164, which is below Maldives, which was ranked 124th, Pakistan, which was ranked 156th, the regional average for South Asia, and also just below India, which was ranked at 163. Bangladesh was ranked below Sri Lanka at 189. So Sri Lanka's ranking shows that in the region, Sri Lanka has to improve. And in my next slide, where Sri Lanka is once again placed against some of its regional partners and also the OECD high income average in relation to certain measures of quality. And shown in this chart. On the left hand, the dark blue bar represents the score for alternative dispute resolution, which is a score between 0 and 3. The yellow bar is the score for case management. It's scored between 0 to 6. The green bar scores court automation, and it is from 0 to 4. And on the right-hand corner, the light blue bar is a measure of court structure and proceedings, where countries are scored from 1 to 5. So looking at this table, Sri Lanka scores 2.5 out of 3 for alternative dispute resolution, which is pretty good. It's actually on par with India and even the OECD high-income countries average. Bangladesh scores higher at 3, that is the full marks. However, Sri Lanka scores quite low in relation to case management, where it has only scored 1 out of 6, and also in relation to court automation, where it has only scored 0.5 out of 4. Once again, Sri Lanka has scored well in court structure and proceedings, receiving 4.5 out of a maximum of 5 marks. So this is also an interesting indication where, for example, we can see that India has done very well in relation to court automation, and even in relation to case management, it has done better than any of the other regional countries ranked in this table. For court structure and proceedings, Sri Lanka ties with India and is placed in the highest ranking among its regional partners in this table. So with that brief snapshot, I'm going to move on to describing Sri Lanka's ADR landscape. In Sri Lanka, we have arbitration, mediation, conciliation, and also adjudication. So we have formal legal frameworks for conciliation, which is the Debt Conciliation Ordinance of 1941. It's still in operation. However, its scope is fairly limited. Then we have an established legal framework for mediation, starting with the Mediation Boards Act of 1988, which established community mediation boards. Community mediation boards are still functioning, and they do, in fact, carry out quite a large volume of disputes. They resolve quite a large volume of disputes at the community level, which are mainly minor civil and criminal disputes. In addition, in 2003, we had the Mediation Special Categories of Disputes Act being passed. Under this act, the Minister of Justice is able to gazette certain special classes of disputes, which are referred to specialized mediation boards. Currently, we have special mediation boards to hear certain land disputes and certain financial disputes. And in the aftermath of the Indian Ocean tsunami, there were also special mediation boards which were created to resolve tsunami-related disputes. Most recently, last year, following Sri Lanka's ratification of the Singapore Convention, the Sri Lankan Parliament passed the Singapore Convention Act. So actually, this was passed just before the ratification of the Singapore Convention by Sri Lanka. And the Singapore Convention Act came into force in August of last year, on the same day that the Singapore Convention came into force for Sri Lanka internationally. So under the Singapore Convention Act, international mediated settlement agreements can now be enforced through the Sri Lankan court system. And finally, there is on the table a mediation civil and commercial disputes bill, which was gazetted in May of this year. And if this bill is passed into law, then all types of civil and commercial disputes will also, it will be able to go for mediation in relation to these disputes as well. And in addition, there is also provision under the bill for court-referred mediation. So in a case that comes up before court, if the judge is of the opinion that this is a fit case for mediation, the judge can refer the parties to resolve their dispute outside court through a mediation service provider. So we have a fairly well-developed regime for mediation. Adjudication is also very popular in Sri Lanka in the construction industry. However, currently we do not have any legal framework for adjudication. So unlike other countries like the United Kingdom, we don't have currently statutory adjudication in this country. What we do have is adjudication under contracts. And finally, of course, we have arbitration. And the legal framework governing arbitration is found in the Arbitration Act of 1995. So with that brief overview, I will move on to today's topic, which is arbitration, starting with a slightly more detailed look at the Arbitration Act. So the Sri Lankan Arbitration Act of 1995 applies to both domestic and international arbitrations. It is indirectly based on the Arbitral model law of 1985. So when Sri Lanka enacted this act in 1995, it became, as far as I know, the first country in South Asia to become an Arbitral model law jurisdiction. In addition to being based on the 1985 model law, the Act also gives effect to Sri Lanka's obligations under the New York Arbitration Convention. The New York Convention was ratified by Sri Lanka in 1969. However, the enabling domestic legislation was only passed in 1995 through the Arbitration Act. The Arbitration Act celebrated its 30th birthday a few months ago. However, despite the lapse of 30 years, it has not been amended up to date. A draft of a new Arbitration Act to replace the Arbitration Act of 1995 was prepared by a committee of experts in the year 2022, and it was circulated for public comments. However, the new act has still not yet been passed by the parliament. So we had, of course, many changes taking place in the country, which may have contributed to the act not really receiving the attention of the legislature. But we are hopeful that the new Arbitration Act will be passed into law soon. Some key features of the 1995 Arbitration Act are that the Act provides for recognition and enforcement of both arbitration agreements as well as awards. So just like the New York Convention, the Arbitration Act provides for recognition and enforcement of arbitration agreements and also recognition and enforcement of arbitral awards. In addition, court intervention has been increased to limited cases. And thirdly, the Act recognizes party autonomy in matters relating to arbitration. So altogether, the Arbitration Act is a progressive piece of legislation compared to we had for international arbitration, parties are free to agree on a foreign law as the substantive law for an arbitration having its seat in Sri Lanka. There are no nationality restrictions on arbitrators, so arbitration seated in Sri Lanka can have foreign nationals as arbitrators. In addition, foreign lawyers can represent parties as either party representatives or as agents. And arbitration hearings can also take place outside of Sri Lanka. So even though the seat may be in Sri Lanka, parties can certainly have hearings at any place inside or outside of Sri Lanka. So these are a few factors which hopefully would make Sri Lanka a contender for international arbitration. Turning to the institutional arbitration landscape, Sri Lanka has two fairly established arbitration institutions. The Sri Lankan National Arbitration Centre, which has been in operation since 1985, and the ICLP Arbitration Centre, which has been in operation since 1996. So both of these arbitrations count many years of experience with both domestic as well as international arbitrations. In addition, in 2018, the ICLP entered into a joint venture with the Ceylon Chamber of Commerce and established the CCC ICLP International ADR Center, known as IADRC for short. It was established in 2018. However, it opened its doors for business somewhere around 2021 or 2022 at its own dedicated premises. And most recently, the International Chamber of Commerce Sri Lanka branch, ICC Sri Lanka, launched its own arbitration and mediation center in September of this year in collaboration with the International ICC. So this is not formally a branch of the ICC International Court of Arbitration. However, it is operated under the blessings of the International ICC. So we have currently 4 main international or institutional arbitration centers. In addition, there are also other smaller centers which are also in operation in this country. So moving on to some of the identified challenges and constraints that have been experienced with the last 25 or 30 years that the Arbitration Act has been in operation in this country. So if you really speak to any practitioner in this country, or even a party who has been through arbitration, everyone will have their own ideas of what is ailing arbitration in this country. So I have tried to be a little objective here, and I have identified challenges and constraints based on available papers and available publications. So these are, I broadly would also agree with what is reflected here, but this is not purely a subjective list. It is based on a broad consensus among leading practitioners in this country. So the first challenge or constraint that we can see in this country is that sittings generally take place in the evenings. Now, it will be interesting for those of you who are participating today who are from the region. I'm sure you can also compare and maybe identify some similarities between the issues that we have been seeing in Sri Lanka and also in your own jurisdictions. So in Sri Lanka, certainly, one of the main problems has been sittings taking place for a few hours in the evenings. And the reason for this is that the counsel who appear in arbitrations are predominantly practicing in the courts. Even many of the arbitrators who are appointed are practicing litigation counsel. So we have seen that these counsel reserve the day for their court work, and they take on arbitrations purely as a secondary sort of source of work. So arbitrations tend to be pushed to 3 p.m. or 4 p.m. or 4:30 p.m. and they last for not longer than a few hours, because the same practitioners who have to appear in court on the next day will need to go back to their chambers or their offices to get ready for the cases that they have the next day. So arbitration sittings would not go on for longer than 2 or 2.5 hours. So it's extremely unsatisfactory and inefficient. Equally, there are no day-to-day sittings or hearings. So we might have a couple of hours today, and obviously you can't achieve much in a couple of hours. So then it has to be postponed. And the postponed hearing is postponed to a date in December or maybe January, or depending on the diaries, because you have to coordinate so many diaries of so many busy people. It might be even later. So in practice, arbitrations take on a character quite similar to court proceedings, because even in Sri Lankan cases, of course, they don't sit in the evenings, but they don't sit or they don't take up trials day to day. So civil trials are not taken up on a day-to-day basis unless there is some really exceptional reason. And generally, you would have a hearing before the judge today, and depending on the workload of the court, it could be postponed for a day in 3, 4, 5, or even 6 months' time. So just like that, in arbitration, we have seen no day-to-day hearings. Another problem or constraint which has been identified in the literature has been dominance of certain retired Supreme Court or senior judges, and also very senior lawyers in the arbitration circuit. So both as arbitrators, you see retired judges and senior lawyers dominating the circuit. And again, as counsel, you see very senior counsel dominating the circuit. So when you have retired judges, one of the things that has been seen in this country is there is a tendency to follow court procedures in arbitrations. So arbitration, which is meant to be the opposite of procedural technicalities or procedural rigidities, takes on a character very, very similar to litigation. equally with senior litigation counsel dominating the arbitration circuit, we also see many technical objections taken up in arbitrations, which probably are founded in civil procedure practice, but uncritically, they are also adopted and applied in arbitration. Another related challenge has been the lack of control of the proceedings by arbitral tribunals. So for various reasons, it has been observed that arbitrators have not been firm with the council to keep the process to an efficient sort of pace. So there are various reasons. Sometimes parties have, or commentators have speculated that arbitrators depend on counsel for their appointments. So if the same arbitrator takes a very tough approach and refuses postponements or insists on day-to-day hearings, for example, it could be that the party is not going to, or that council is not going to appoint that arbitrator again. So there is that conflict of interest. So because of this perception that you depend on parties or council for your appointments, it can also result in arbitrators not being strict to enforce timelines and to enforce discipline to make sure that the process takes place efficiently. Related to what I just said is also this perception that arbitrators are biased towards their appointing parties. So in fact, in Sri Lanka, even to some extent among the legal community, there is a perception that the arbitrator who is nominated by a party is their arbitrator. And that's reinforced by the practice that each party is responsible for paying the fee of the arbitrator who they nominate to the tribunal. So if I am appointed, for example, to an arbitration by a claimant, then the claimant is responsible for settling my fee. And the respondent would be responsible for settling the fee of the arbitrator who they nominate. And of course, the chairperson's fee would be shared equally by the two parties. So the parties and sometimes even their counsel feel that because they choose a particular person as their nominee on the tribunal, and also because they pay that person's fees, that that particular arbitrator should sort of advocate their position in the tribunal. So this is in fact not correct, because in keeping with the model law, the Arbitration Act of Sri Lanka also requires that all arbitrators must be independent and impartial. So irrespective of whether you were appointed by a party or by your co-arbitrators, or whether you were appointed by an arbitral institution, every single arbitrator in Sri Lanka is legally bound to be independent and impartial. But this is sometimes not the reality. And in fact, sometimes even arbitrators themselves seem to be under the impression that they have to represent, or they have to somehow promote the interests of their appointing party. So this is a serious concern as well. Then there is, of course, a lack of technology adoption, which we can see in most arbitration proceedings. So today we are in an era of unprecedented technological advancement. Everyone is talking about AI and what AI can do. However, technology adoption in arbitration practice in Sri Lanka is quite low. The only exception was during the 2 years that the COVID pandemic was really having a firm hold. Then arbitration hearings moved to hybrid or virtual hearings. So that was actually a very promising development where we actually had arbitrations which entirely took place virtually. Witness examination, cross-examination, all of that was done without really any problem, I would say, virtually. But sadly, no sooner that things came back to normal, parties and counsel and even arbitrators were more than happy to get rid of this technology and go back to the familiar ways of doing things. So actually that's, I think, a problem which I see a lot in anything to do with the law, because lawyers, by training, we have this tendency to always look to the past because of the common law tradition. In a way, everything is based on legal authorities. If you can find a case from somewhere in the past where something was done, then you use it to do it in the future. So we are really stuck with this mindset of precedents from the past and still following them with little tweaks. So in the same way, when things came back to normal after the pandemic, we are now happily gone back to all the old ways of doing things. There are exceptions, of course. Certainly with international parties, we do have remote hearings, but for purely domestic arbitrations, remote hearings are very, very rare. Another constraint, of course, is that whenever you need to go to court for anything, so even under the Arbitration Act, there are certain situations where parties will need to go to court, whether it is to appoint an arbitrator or whether it is to challenge the tribunal's jurisdiction, or whether it is to enforce or set aside an arbitral award. For example, there are certain defined situations where parties will still go to court. And in court, of course, we have the situation which is experienced across the board in civil as well as in civil, in criminal litigation, which is that there are huge delays. So just to give an example, sometimes when a party wants to commence an arbitration process and the other party refuses to appoint an arbitrator, then you have to go to court. If it is an ad hoc arbitration, then you have to go to court, appoint the arbitrator. And getting an arbitrator appointed in court can take up to a year or even longer. So imagine the arbitration process cannot commence for a year or longer because we are waiting for the court to appoint an arbitrator. Similarly, there are delays in every other type of application made to court. Then, even though the Arbitration Act was, I think, a regional first when it was passed in 1995, as I mentioned, It is 30 years old now, and it has not been amended to date. Many things have changed in the last 30 years in the international arbitration arena. So the Arbitration Act is really showing its age. So it is really high time now that the Arbitration Act was replaced. So these are, I would say, the main challenges and constraints that we have seen facing arbitration in the last 30 years. Of course, before I leave this slide, I must also say that things have really been changing as well. Certainly, I would say that in the last 5 years, there has been a noticeable shift, because we have seen a new generation of people who are entering as counsel, as arbitrators, as people working in arbitration institutions. And these people have been educated or exposed to some of the international best practices in arbitration. So we can see that there is slowly a change taking place. However, still that is not enough. So a lot still has to happen. Now I'm going to shift to a focus on arbitration institutions. If you take arbitration institutions in general, at the most basic level, they can be seen to exercise certain administrative and secretarial support services for both institutional as well as ad hoc arbitrations. At the most basic level, arbitration institutions can be seen to provide certain administrative and secretarial support services in aid of institutional and ad hoc arbitrations. For example, for institutional arbitrations, confirming the commencement of the arbitration. For both types of arbitration institutions are involved in collection and management of deposits and fees. In addition, they commonly provide or arrange hearing room facilities and also the necessary transcription services or stenographers and so on. So interpretation, transcription, and services of those nature are usually organized and arranged by arbitration centers. In addition to that, arbitration centers also commonly coordinate communications between parties and the tribunal. And finally, in institutional arbitrations, arbitration institutions also exercise overall supervision of the proceedings. However, apart from these basic functions, arbitration institutions also, especially the more developed institutions, exercise an enlarged role. And I came across this very interesting quotation. Arbitration institutions can be described as a guardian that protects and defends the integrity of the arbitration process and ensures it is not derailed. It is a gatekeeper that controls access and decides who may participate in the process. And finally, it is a guide to help parties reach an enforceable resolution. So in this enlarged role, arbitration institutions can be seen as guardians of the arbitration process, of gatekeepers, and also as guides. And this quotation is from a recent lecture that was delivered by Claudia Solomon, the president of the ICC court. So seen in this enlarged role, some of the wider functions which arbitration institutions can also perform include adoption of up-to-date arbitration rules and case management processes, appointment of arbitrators and emergency arbitrators, deciding on requests for joinder and consolidation, deciding on arbitrator challenges, scrutiny of awards, and finally, conducting training, awareness raising, and advocacy. So these are all examples of the enlarged role that also can be played by arbitration institutions. Just to take an example of the advocacy role that arbitration institutions can play, even I was quite surprised when I was doing my research for this lecture that I learned for the first time that the New York Convention was in fact drafted by the ICC. So it was the ICC which really lobbied for the Geneva Conventions to be replaced by a more modern international treaty. And it was the ICC which in fact drafted the first draft of the New York Convention and handed it over to the United Nations. So arbitration institutions can in fact play, and they have in fact played, a very important role in terms of wider advocacy and in addition, training and awareness raising. So against these functions, how do the Sri Lankan arbitration institutions measure up? Well, on the positive side first, most of the Sri Lankan arbitration institutions do have updated arbitration rules. All of them, or at least the established centers, have modern hearing rooms with facilities for virtual or remote hearings. They also have quite competitive fee structures. The more established arbitration institutions have the benefit of experienced administrative support staff who are well versed with how to conduct an arbitration. And also, many of the arbitration centers in Sri Lanka also do have their own separate training and awareness raising activities. So for example, the ICLP Arbitration Center is its parent, the Institute for the Development of Commercial Law and Practice, has for many years, over 15 years, been conducting a successful diploma program in commercial arbitration. Similarly, the International ADR Center has taken the lead role in promoting commercial mediation in this country through organizing several trainings and workshops targeted at the legal community and also the commercial community. So these are some of the positive things that we see in the Sri Lankan institutional arbitration landscape. However, among the drawbacks, one drawback is there is no published statistics or reports. So none of the arbitration institutions publish statistics of their cases, how many cases were instituted, how many cases were disposed, what is the age analysis of their caseload. So without data, really, it's very difficult to make policy decisions. I'll come back to that later on as well. Secondly, the institutional arbitration centers in this country still predominantly rely on manual systems for case management. Technology utilization is also quite low. So sometimes arbitration centers in this country have been likened to post offices. And there is a certain truth in that also, unfortunately. So arbitration centers process a huge volume of paper. They receive statement of claim from the claimant, then they print out a covering letter, and with the covering letter, the statement of claim is copied and dispatched by post to the respondents and to each member of the arbitral tribunal. So multiplied into the number of cases, arbitration centers do in fact resemble post offices to a significant extent. So using email for communications is quite rare, strangely, for some reason, unless the arbitral tribunal takes the initiative. Most communications take place through hard copy, through the post. Another problem has been limited financial resources. So the multiplicity, in a way, of arbitral institutions has also led to arbitral institutions being quite constrained when it comes to any sort of expansion, because they operate with very small margins. And a final drawback is that in Sri Lanka, the vast majority of domestic arbitrations are ad hoc arbitrations. Arbitral institutions have a very limited role when it comes to ad hoc arbitrations. Their role is usually confined to providing hearing rooms and support services. So unless there is wider adoption of institutional arbitration clauses, it's very difficult for arbitration institutions to take a more proactive role to make arbitration proceedings more efficient. Now, briefly, I'm going to look at the courts and how arbitral awards are enforced in Sri Lanka. If we start by looking at what are the requirements for enforcing an award. In order to enforce an arbitral award, you have to make an application to one of the designated high courts. Currently, the Minister of Justice has designated the high courts of Colombo, of Kandy, and Jaffna for arbitration matters. So if you want to enforce your arbitral award, you have to go to one of these three high courts. There is time limit for enforcement applications. The application should be filed within 1 year after the expiry of 14 days from the date of the award. So basically, you have the date of the award. The enforcement application should be made within 1 year and 14 days. The application should contain the original of the arbitration agreement and the original of the award, or certified copies of these documents. So technically, you only need to support your application with 2 documents. They are the arbitration agreement and the arbitral award. If either the arbitration agreement or the award is in a foreign language, then you are also required to file a translation. So these are the basic requirements for an enforcement application. On the other side, how are awards challenged? In Sri Lanka, the main statutory remedy to challenge an arbitral award made in Sri Lanka is a setting aside application. A setting aside application must be made to one of the high courts within 60 days of receipt of the award. So there is a much shorter time frame for a setting aside application. It is 60 days from the date of receiving the award. The grounds on which an award can be set aside are found in Section 32 of the Arbitration Act, and they correspond to the grounds in Article 34 of Model Law and, in turn, the New York Convention. The grounds on which an award can be set aside by the High Court are exhaustive. So the High Court cannot set aside an award made in Sri Lanka on any ground other than the grounds which are specified in the Act. An application to set aside an award is not an appeal. So this is also very important. The court will not review the merits of the award in a setting aside application. In other words, the court will not go into seeing whether the award is right or wrong in a setting aside application. Exceptionally, in a setting aside application, the court may, instead of setting aside the award, remit the award back to the arbitral tribunal for correction. The procedure that is followed in court is a shortened procedure for both enforcement and setting aside applications. There are no oral hearings in either case. So, in the case of both enforcement applications and setting aside applications, the court will give its decision based on the written pleadings filed by the parties and on the written submissions filed. So usually, in as little as 3 or 4 days, an order can be expected. So on the first day, so initially the party will file their application for enforcement or setting aside. Then the application will be served on the other party, on the respondent. They will come into court and be entitled to file their objections, supported by affidavit. After the objections are filed, written submissions will be filed by both parties, and then the matter will be reserved for order. So it is a fairly shortened or abbreviated process, where both enforcement applications and setting aside applications are pending at the same time. The court is required to consolidate them together. The decision of the High Court, either on an enforcement application or a setting aside application, can be appealed to the Supreme Court on a question of law with the leave of the Supreme Court. So there is no automatic right of appeal. A party who wants to appeal is required to satisfy court that there is a question of law sufficient to grant leave. Parties may enter into an exclusion agreement to exclude the right of appeal to the Supreme Court. So the Arbitration Act also provides for parties to enter into what are called exclusion agreements, where they can agree to exclude any right of appealing to the Supreme Court. So what is the attitude of the courts? Over the last 25 years, the Sri Lankan courts have moved from a pro-intervention approach to a pro-arbitration one. So we can see this as a very positive development. Initially, when the Arbitration Act was new, we saw the courts taking a fairly interventionist approach, whereas now, with the experience that the courts have also had with 30 years of the Arbitration Act, Sri Lankan courts are broadly pro-arbitration. Arbitration agreements will usually be enforced by courts as long as the objection is raised in a timely fashion. Sri Lankan courts have also taken a very restrictive view of the public policy ground of refusing to enforce an arbitral award. So as you all know, one of the grounds on which an award can be set aside under the model law or can be refused recognition and enforcement under the New York Convention is if it is contrary to the public policy of the seat. So public policy grounds are frequently raised by parties in challenging awards. However, the courts have taken an extremely restrictive view that, save for very extreme situations, awards will not be refused enforcement on the ground of public policy. However, the delay in the court system remains as a serious concern. So if we are looking at an enforcement or a setting aside application in the commercial high court, it can take anything from 2 to 3 years in the high court. And if leave is granted to the Supreme Court, it can take up to another 3 to 5 years. So you're looking at a total period of around 5 to 7 years in court to enforce an arbitral award. So that remains a serious concern. So with that, I'm really at the tail end now of my presentation. Way forward. What needs to be done? So broadly, I think many people are in agreement in relation to the problems which I have outlined. And equally, I think there is also broad consensus on what needs to be done. The challenge is how to do it. So what needs to be done? Well, it requires a multi-pronged approach. The arbitration ecosystem has many actors, from parties to counsel, to arbitrators, to arbitration institutions, to courts, to the legislature, to international organizations like Council-SARCO, like SARCO. There are many actors, to universities, law colleges. So these problems which I have referred to require action by not one single entity, but by many of them, if not all. However, whatever approach that is done, it must be data-driven. Too many times, legislative reforms have been based on subjective evaluations. This cannot be done. You must base interventions on tangible empirical evidence. So we really need to invest in having accurate, up-to-date data. So the responses themselves can be short, medium, as well as long-term. Without being in order of priority, these responses must include attitudinal change. So the attitudes of parties, of arbitrators, of arbitration centers, of counsel, they must change. Incentive structures must change. So why do lawyers give second priority to arbitration hearings? That arbitration hearings are confined to a few hours in the evening. It's incentive structures. It's simple, right? If arbitration hearings can be made as attractive to counsel as appearing in court, then you can expect counsel to be more ready to take up arbitrations on a full day or a day-to-day basis. So incentive structures have to be addressed. Institutional reform, of course, goes without saying. So this includes the courts, it includes arbitration institutions, and I have also highlighted here the Attorney General's department also, I believe, has a very important role in this process. Because if you take domestic arbitration in this country, most domestic arbitrations, or at least a large number of domestic arbitrations, are construction arbitrations. That is because the standard model contracts that are used in the construction industry contain arbitration clauses. Now, the biggest employer in the Sri Lankan construction industry is the state. So most of the construction disputes which come to arbitration will involve either the state or a state entity as a respondent. And usually when the state or a state entity is a party in an arbitration, they are represented by the Attorney General. Now, the Attorney General's department does not have a separate unit currently dedicated to arbitrations. So it is the same counsel who appear in the courts who are assigned to appear for arbitrations. So again, even if the private counsel are willing to sit in the morning, the counsel representing the Attorney General's department is not able to sit in the morning because they have been allocated to appear in the courts. So definitely we need to see some changes also happening in the way that work is allocated within the Attorney General's department. And finally, of course, as I have highlighted, we need legal reform. So what can arbitration institutions do? One thing that arbitration institutions can do is to promote wide adoption of institutional arbitration clauses in their contracts. So it is only if parties incorporate an institutional arbitration clause in their commercial contract that the institutions can play a more proactive role in making the arbitration process efficient. If it is purely an ad hoc arbitration, then the institution's role is very limited. So one thing that institutions can do is to promote wide adoption of their institutional clauses in contracts. To do this, they should engage directly with commercial parties and with general counsel. So you have to basically create a demand from the client. The client has to demand efficiency. The client has to be in the driving seat. Institutional arbitration centers can also continue to support the education and training work that they have been carrying out. And it can be also rolled out for arbitrators, lawyers, and also expert witnesses. In addition, arbitration institutions in this country can implement best practices through international and regional collaborations. And also they can lobby the government for legal reforms. All of this will require the arbitration institutions to take a collaborative approach as opposed to operating in silos, which we have sometimes seen in the past. And finally, in my final slide, I also have some thoughts as to what SARCO can do in this process. So many of the challenges which I think I have spoken about would probably resonate across the SAARC region. Certainly, I'm quite familiar that in India also, many of these challenges are felt. So SARCO, which is representing the SAARC member states, is uniquely placed to play an important role in promoting best practices in the SARC region. In fact, SARCO's work already has included conducting tailored capacity development programs, workshops, and seminars, both in member countries as well as online. So this work is to be welcomed, and it can be continued and rolled out to a wider audience. In addition, I would like to see SARCO promoting appropriate dispute resolution, which is a mindset shift from alternative dispute resolution. So appropriate dispute resolution is a new term where we see litigation, arbitration, mediation, conciliation, all of these as suitable in particular instances. So it's not that always arbitration is superior to litigation, or it's not that always mediation is superior to arbitration. Instead, practitioners should be able to recognize that all of these are simply different tools in your toolkit, and that you need to know how to select the best one. Another area where I feel that SARCO has a potential is to focus on being a center for investment arbitration disputes. So currently, Sri Lanka and also other countries in the region have had to face investment arbitration disputes. And if you have to go to ICSID, it is a huge expense. So other developing countries, especially in South America, have been trying to come up with regional alternatives to ICSID. I believe that SARCO is uniquely placed to focus on becoming a center for investment dispute resolution. Finally, I also would like to see SARCO maybe considering developing some kind of professional accreditation for arbitrators. Currently, if someone wants to gain accreditation in arbitration, their options are either to follow the accreditation process of the Chartered Institute of Arbitrators or a similar international institution. SARC has a lot of commonalities, both in legal cultures as well as the challenges that we are facing. So maybe if SARCO can take a lead role in developing some kind of homegrown accreditation system for arbitrators and even maybe mediators, I feel that would also be very valuable. And also, I think SARCO can also collaborate with institutions or with universities to help develop curricula on arbitration and ADR. So finally, all of this requires education. And we have to start with the current generation of students in universities or in law schools. So I feel that SARCO also can collaborate with some of these institutions, maybe help to establish certain regional centers of excellence where people really can go to specialize in arbitration and ADR. So with that, I think my time also I have exceeded. I'm extremely sorry, but I think with that, I will stop. Thank you.
Thank you very much, Mr. Rajapakse. Let me just close the slide, actually.
Yes, I'll just close it.
Okay, thank you. So thank you for the very comprehensive and some very interesting insights as well. I was making notes throughout the presentation, and I'll just make some very minor observations from my perspective. So it's very interesting to see that Sri Lanka is comparatively lower on the enforcement graph compared to other member states, but I believe that we are making progress in that regard. You also mentioned that currently you had your 40th anniversary of the Arbitration Act in Sri Lanka. In the case of Pakistan, we will most likely will have our 85th anniversary of the Arbitration Act, which is currently in force. So still better than that. But I did have some queries with regards to the fact that there was an act which was proposed and maybe a draft was made. And we understand that there was some economic turbulence in the last 2 or 3 years ago, maybe. But since then, I believe things have settled down a bit. So even then, no improvement or no update has been on the latest Arbitration Act of Sri Lanka.
Well, it has been passed from person to person in the government. So there have been so many changes in ministries, in heads of department, in secretaries. So currently, as far as I know, the Bar Association is really pushing the new act through. So I'm not aware whose approval it is right now pending for, but the Bar Association is certainly pushing it through.
Okay, so because SARCO has its own diplomatic connections and we work at a more diplomatic level, we would
Yes.
be more than happy to provide any support that we can to hopefully ease the process or maybe make any suggestions ourselves as well for the passing of the law, not just for the arbitration, but also the current civil mediation, the
Yes,
mediation act
certainly.
as well. Additionally, you also touched upon a lot of challenges, which I feel were very universal in nature. The prevalence or the dominance of senior judges and lawyers, the fact that there are delays in some enforcement matters or in the hearings process. I just had one question in that regard, that what is the role of institutions when it comes to these kind of arbitrations? Because I assume that the institutions can play a more proactive role in easing the process, making it more consistent, making it maybe if not during evening time, during daytime, or trying to maybe complete the whole process within, say, 5 to 6 hearings. So how does the institutions play their role?
Right. So now, if it is an institutional arbitration governed by the institutional arbitration rules, there is a certain level of discipline because, for example, under the ICLP arbitration rules, an award has to be made within 18 months of the first hearing. So the initial case management conference, which takes place within 18 months of that day, the tribunal should make its award. And if not, you have to go to the board of the ICLP and you have to justify the reason why you're asking for further time. So that itself, it sort of has an impact on the parties also when they are giving given dates for their pleadings or when they are given dates for the witness hearings, because the tribunal will always tell them, look, we have to give the award by a certain date, so please, agree on short dates, for example. But as I said, most of the arbitrations are ad hoc. I would say that really around 90% of domestic arbitrations are ad hoc. So then the arbitration rule really has no authority to intervene and say, give the award by this date. It's really then between the parties and the tribunal. So if the tribunal is lenient, and the parties are also not in such a hurry, then the whole process gets dragged.
Okay. One last observation that I had, which was on the exclusion agreements, that parties can exclude
Yes.
the right to appeal to the Supreme Court. How does that work?
Yes.
I mean, I find that very interesting that you are giving up a legal right, which can maybe come into
Yes.
hand as well.
It's very interesting that the Arbitration Act of 1995 introduced this innovative provision, because it's certainly not there in the model law, which the act is indirectly based on. So the act provides that exclusion agreement can be entered into in writing. It can be entered into even before or after the award is given. So it can be actually in the contract itself. It can be in the arbitration clause itself. It's fine. And you basically give up the right of appeal. So you're basically saying that you will be bound by whatever the decision that is given in the High Court. But having said that, so it's legislatively provided for. So giving up the right is true, but it is there in the law. So then it's, then it is perfectly permissible. But I should say that I have really never seen an exclusion agreement actually in practice, and I think that parties are very reluctant to agree to exclude the right of appeal because I think they would always want the assurance that if the High Court decision is, for whatever reason, legally wrong, that they should have some recourse against it.
Yeah, that would make more sense. On the role of SARCO, a lot of interesting points were raised. I'm just going to transfer it to our DG to maybe give his remarks on the points that you raised for the role of SARCO.
Thank you so much.
Right. Can you hear me?
Yes.
Okay. I think it's a very, the observation you made are all valid observation. And in a way, I think your thinking and also our thinking here in SARCO, we are on the same wavelength. Last year, we have carried out whether we are fulfilling our mandate or not against the activities we have undertaken so far. And that assessment shows two things. One is in terms of promotion of arbitral institutions in the member states, we are doing a lot of webinar, seminar, and workshops. But what we have found out was really those events are not really based on the needs of the participants or the arbitrators or the mediators in the member states. Now we are going to shift away from this in the sense that let's find out what arbitrators or mediators in the member states really need and then deliver. In fact, that was the plan, and as I mentioned earlier, because of this plan, based on this plan, we have, in fact, actually planned physical training activity, tailor-made training activities this year. But because of factors beyond our control, we are not able to really deliver the specific or the tailor-made training program. So we are, even in 2026, we are trying to do exactly the same thing. That is to deliver a very tailor-made specific training programs. If the condition or situation improves, this is really our the way forward. But for some of the countries, for example, like Bhutan, the ADR institution in Bhutan, what they have in plan is they want to provide a series of training programs. So these training programs are tailored to meet the requirement that will ultimately lead to certification by competent or the recognized international arbitral institution, the centers. So they were talking about basically SIAC in Singapore for Bhutan. So we would like to, when we assess the training needs in the member states, and when we conduct the training in the member states, this is how I think we should also go about it. And if there are certain activities that need to be fulfilled in order to get certification, so we can take up those activities in the member states in the form of tailor-made training program. So this is the thing we are also thinking about it. And other things, what are the other things? Other things in terms of promoting the international best practices, and also you have mentioned again and again, last year we had also, I think you are one of the resource speaker, but it was led by other institutions, and they were also mentioning about the training requirement, and also if we could really, SARCO could coordinate and bring together the relevant sectors like judiciary, contractor association, then the business chambers, bar council association, together in the form of regional seminar. And then what will happen there is, for example, the people from Sri Lanka will make their presentation on the prevailing laws and practices in Sri Lanka, and Bhutanese participant will do the same thing for Bhutan. And also, we are also thinking about in that regional conference on area laws and practices, we could also bring in international experts, so that that expert can share the international best practices to the participant. And at the end of 2 days or 3 days event or programs, what we could do is we have this ready-made reference booklet on the arbitration laws and practices in South Asia, including the international best practices. We are planning this one also, and I hope we can have the conference during my tenure, and we can hopefully, we are exploring the financial issues. That's the biggest issue we are facing right now. And I think in terms of mainstreaming the ADR processes, or in terms of extending the public education or awareness programs, we are right now, SARCO is in the process of forming young arbitration group. This, of course, is not the awareness program that will cover all levels of citizen or population in the country. But what we are trying to focus is we want to groom the prospective or the mid-career ADR professionals below 40 years of age. This is already being planned, and we have also already circulated our application forms through the member states. And of course, unfortunately, we have received so far only one application. But moving forwards, what we are thinking is we are in the process of developing our website. We'll have online application portal there, so they can apply online directly to us, and then we'll assess, and then ultimately that will lead to formation of young arbitration groups. I think that this will also take care certain aspects of what you have suggested on your in your presentation. I think those are the key important issues you touch upon, and if I have not addressed any issue, just let me know. So we will, try to supplement.
Sir, you're muted, Mr. Rajapaksa. Mr. Rajapaksa, you're muted. If you can unmute.
Sorry. Thank you very much for that explanation, and I'm really encouraged by what I heard. So I look forward to seeing the work that you're going to achieve.
Thank you, Mr. Rajapakse. We had a few questions which I'll ask you, but just before that, if I may request Mr. Khurram Saab, sir, if you may have any observations or questions. Sir, you're muted. If you could unmute. Yeah. Sir, can you hear me, Khurram Saab? So we can't hear you. If you could unmute your thing. Till Khurram Saab is able to unmute himself, if I may request Ruhul sir, if he may have any observation questions you may want to raise.
Thank you. I have just amazingly was listening to our keynote speaker. Thank you, Mr. Amrit Rajapakse. First of all, I would like to extend my heartfelt thanks to the keynote speaker, Mr. Rajapakse, Amrit Rajapakse. He has nicely explained the topic, especially mediation, arbitration, ADR system in Sri Lanka. Am I audible?
Yes, sir. Yes, sir. We can hear you.
Okay, thank you. Special thanks to our Honorable DG of SARC Arbitration Council, Mr. Chengmin Dorji, and also to Barrister Sakib Manglio for arranging such an excellent webinar. Thank you. I have actually attentively listened to the keynote speaker. I think Sri Lanka has achieved a tremendous development in arbitration practice. Actually, this webinar emphasizes on arbitration institutions and enforcing arbitral awards. But here we have heard, especially keynote speaker touched the ADR system, especially ADR in arbitration, conciliation, and mediation. I have a simple question about mediation. I was going through internet, especially on mediation, and here it was inserted that most probably, if I am not wrong, what I have seen, 250,000 cases are mediated on an average every year. It is a huge number, I think, if it is correct. And here, there it was inserted that 65% annual disputes are settled by mediation system. If it is true, then I think under mediation, through mediation, 65%, and if arbitration, conciliation, this can enhance the resolving percentage of the cases. In that case, regular process of disputes, whether it is a small number or a large number, if you can make a simple or explanation on this point. Thank you.
Sorry.
Okay. 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 Thank you. Oh, you are mute.
Sorry, you referred to the statistics that there was a very large number of disputes that have been referred to mediation. So that would be community mediation. I imagine that the statistics which have been reported are all community mediation disputes. So these are those minor sort of community level civil and criminal sort of complaints, but we don't have statistics for any other types of arbitration or conciliation, really. What was your question, please, if you don't mind?
Okay, I got your answer. Community-based mediation. Can you explain,
Right.
please, again, what are the composition and functions of the community? That is, you have community mediation board, I think.
Yes.
Community mediation board. If you could explain the composition and the functions, how they perform the mediation practices.
Right. So
Composition of community mediation boards.
certainly. So the community mediation boards, which have been functioning since 1988 in this country quite successfully, they are comprised of really people who are respected in their community. So it could be retired school principals, it could be religious leaders, it could be public officers. So generally, the people who sit in these communities, they are lay people, or they are not trained lawyers or retired judges. That's what I meant. And they receive a training of basic mediation skills from the Mediation Board Commission, which is the government authority that oversees the community mediation boards in the country. So with that training, they take up these disputes. And it's not really the formal commercial mediation process which is followed. They generally improvise their own procedures. And they usually use their sort of respect in the community to convince the parties to settle, if that's possible.
Okay, thank you. There is no role of judges or the advocates in the community.
No, and in fact, the Mediation Boards Act, as well as the Mediation Special Categories of Boards Act, has specifically provided that lawyers cannot appear for parties before those boards.
Okay.
So it is only the parties themselves who can appear with a friend or a family member, but they cannot go with lawyers. So these are very informal places.
Thank you. Thank you very much.
Thank you for the question.
Thank you, sir. Khurram Saab, would you have any observations or any questions you may want to ask?
Yeah, thank you very much. I'm sorry I couldn't hear you earlier. Thank you very much. I'm really impressed the way, the webinar has taken place and the insightful way the speaker has given us the very much insight of the entire process in Sri Lanka. So I'm really impressed by the way it has been presented. The presentation was very thought-provoking, and it was very in a way, it has given us the inside knowledge. And I am impressed in a way that, it is not arbitration, it's not only the way the matters have been referred to arbitration, but the confidence the people have in the arbitration that the matters, the cases have been referred to arbitration is very thought-provoking, and we are really impressed, and we will request Sri Lanka to help us, because we have a very old arbitration law, which is 1940, before the partition of Pakistan, and we are still, taking that forward. Even though we are in the process of, making a new law in this respect, and we are, we have compared the other laws of arbitration around the world, but I think, Sri Lanka has got a very good law through which they are handling this dispute resolution through this way, the alternate dispute resolution through arbitration. So I can only say that, I couldn't attend the entire webinar, and, I regret that because I was busy in another meeting. So when I came in and, what I have heard It was very insightful and it was very informative. And I believe that, this kind of webinar has given all the rest of the members who have attended the entire webinar, it has given them a very thorough knowledge about the entire process and the procedure which has been adopted in Sri Lanka. So once again, I am very thankful to the organizers and to Sri Lanka, the speaker, and to all the rest of the colleagues. Thank you very much.
Thank you, sir. Thank you for the very kind words. So, Mr. Rajapakse, just before we conclude, we have 3 questions. Since we are a bit ahead beyond our time, I would really appreciate if you can just do some very brief answers. So the first question is, what are some reforms? What other reforms are most critical to make Sri Lanka a credible arbitration-friendly seat in South Asia?
Right. So I think other reforms, I'm not really sure what that encompasses, because I was trying to give a very sort of comprehensive reform package, which includes legal, institutional, attitudinal, and incentive structures. So I believe that if we can effectively address these areas, I think that's what we require to do. So there really is no other reforms that I can think of, at least.
Thank you. Second question, what single institutional reform, the rules, case management of fees, would most quickly cut arbitration timelines in Sri Lanka?
Right. So I think it would be the wider adoption of institutional rules, because rules impose a certain discipline on the process. So if parties can be convinced to include institutional arbitration clauses in their dispute resolution clauses, that will give the arbitration institutions the necessary authority to play a more sort of proactive role in the process. So I would say to have the clause, that would be probably the most significant.
Okay. Last question. So I think you mentioned during the presentation that there's a lack of data available in Sri Lanka.
Yes.
So what data should institutions and courts publish? For example, timelines, cost enforcement rate, to drive accountability and continuous improvement.
Well, I think at a basic level, because of course arbitration proceedings are confidential, but at a basic level, it will be useful to see the number of cases that are pending at the start of the year, then the number of new cases that were filed during the year, the number of disposals, and then the closing case tally. And also an age analysis would be useful to see the relative age ranges that cases are pending, and also a sectoral analysis, because then we can actually see which sectors are the main users of arbitration services, and across years we can see trends. So that can also help us to focus our attention on those particular sectors. So to make strategic decisions like that, we really do need data. Otherwise, you can't do it. Given the confidential nature of arbitration, you really can't make guesses and decisions.
I think no more questions, so we have officially closed off the webinar. I'll just briefly do the concluding remarks. So, ladies and gentlemen, I extend my heartfelt gratitude to all of our participants in the speakers who have contributed immensely to the success of the event. It has been inspiring to see the level of engagement from the program, and I think that the insights will play a huge role in shaping the future of India, especially with respect to the timely and effective enforcement of arbitral awards to ensure arbitration reaches its necessary conclusion. Before I conclude, Mr. Rajapakse, would you like to say in concluding remarks?
Sorry?
Would you like to say in concluding remarks, sir, before I just...
Oh, no, I really enjoyed this opportunity to share views with colleagues from the region. And I think a lot of these things I spoke about seem to be quite common in the region. So I look forward to working together, either individually or through institutions, and trying to improve things for the future. Thank you so much.
Thank you, Mr. Rajapaksa, and thank you, everyone. We are ending the webinar, and thank you, everyone, for joining, and until next time.
Thank you.